Well, good morning, everyone. This is George Spees with the Pennsylvania Office of Open Records. I'd like to welcome you to this morning's webinar, where we're going to be talking about basics of the Sunshine Act. A couple preliminaries before we jump into the actual presentation. This session is being recorded, and these recordings are available. As the process currently exists, what you can do is send us a flash drive with a note and a self-addressed stamped return envelope, and we'll be happy to make that recording copy on the flash drive and mail it back to you. Turnaround lately has been about a week, so it's fairly quick. There's also the possibility that this presentation could be made available on a file sharing platform. So you want to check with the staff, perhaps when you send us an email or phone call, to see whether or not there might be an easier way to go about getting a copy. The PowerPoint that I'm using is available on our website on the training page, and you scroll down and all of the PowerPoints that we use for webinars and other applications are on there. You're welcome to use those for your own future reference, or maybe you're doing some local training and you would find that helpful. Feel free to have at it. We consider it to be in the public domain, and anything we can do to help your efforts with your training on the Sunshine Act is fine with us. Finally, if you have, and let me jump in here. I'm kind of getting over a cold and I've got this dry cough that is hanging on. So I'll just ask your indulgence if I start coughing or anything like that. I'm sorry about that. Finally, if you have any questions during this presentation, the way that it works is, if you've never participated before, we've got the PowerPoint presentation with me talking. And if you have a question, please feel free to type it in to the meeting chat feature, and I'll try and answer the questions as we're going through the presentation. Pardon me. However, I would ask two things. First is that, we are talking about the Sunshine Act, so keep your questions on topic. Also, try to keep your questions as brief as possible. It's somewhat awkward for me to sit here and read through a couple paragraphs while everyone is patiently waiting. If it looks like it's something specific to your situation or something unusual, complex, we'll do one of two things. We'll either wait until the end of the presentation and I'll come back to that particular question and address it then, or we'll take the conversation offline, where you can either call in or send an email into the Office of Open Records, and someone will get back to you. There's even a possibility that they might forward it to me, but we'll try and get you steered in the right direction nonetheless. Okay, so that's all the preliminaries. Let's go ahead and jump into the presentation itself. I think it's important to begin with a foundational statement, a fundamental precept about what the Sunshine Act is all about. And yeah, it's also known as Pennsylvania's Open Meetings Law. So that kind of gives you a general description. But I think it's really cool to look at, what I would define as the preamble to the Sunshine Act. And this is taken right out of the act itself. The right of the public to be present at all meetings of agencies, witness the deliberation, policy formulation, and decision making. Okay, so that it maintains a democratic process, and that secrecy in public affairs undermines the faith of the public in government and the public's effectiveness in filling its role in a democratic society. Okay, very high level altruistic language there, but yet when you break it down, it really does speak to the public, or the public's right to witness the decision-making process that our elected officials are going through. And, I think every public official needs to read this and understand the importance and the foundational concepts that go into what governs the meeting. And from my perspective, I've identified, or we've identified, what we consider to be the big three, the three legs of the stool that are critical to ensuring the public's right to witness and participate in the decision-making process. The first is that all public meetings need to have advance notice and instructions on how to attend. For a physical meeting, obviously, you'd want the date, time, and place where the public can gain access. If there's an online component, then you would have, the URLs or the email addresses or whatever, phone numbers for how you would sign into the meeting. The second leg is the public's right to observe the deliberations. Okay, so we have instructions on how to get there. Now we need an environment as such that the public can easily observe and understand what's going on with the decision-making process. And then finally, a big one is the right to comment, the public's right to comment on decisions prior to those decisions actually occurring. Okay, so there's this thing that we'll talk about, the public comment period, and not only just how that is so critical, but also how that needs to occur during the public meeting process. Okay, so let's jump into some specifics here as far as the Sunshine Act is concerned. And whenever I tell someone about, understanding a law, whether it be the Sunshine Act or in the case of the Office of Open Records, the Right to Know law, oftentimes other laws that come into play that have an impact on the decision-making process, I tell them how important it is to understand the definition section of that law. Because as you're reading through a law, there may be language that is somewhat vague or legalistic, or maybe, it appears to conflict with itself or another law. By going to the definition section and seeing what words actually mean, a lot of times it can shed light on your understanding of how this law is applied and how it works. And the Sunshine Act is no exception. To gain a truly full understanding of the Sunshine Act, you need to take a look at the definition section and how it defines meetings, public meetings, citizens, and so forth. But let's take a look at and answer the question, who is covered by the Sunshine Act? And here, we're taking a look at language actually taken from the Act and those definitions that I referred to. So this is language just out of the Act itself. It applies to any state or local government body and all committees. Note that the term committees is italicized because that question often comes up. Is our committee covered by the Sunshine Act? So this is a starting phrase, and some people think it's all encompassing. As we get into some further definitions and some case law, this will change somewhat, but I think it's important to understand that the starting point is that committees are covered by the Sunshine Act. But then we add to that definition that perform an essential government function. And this can be important because you can have committees assign missions or tasks that aren't necessarily an essential government function. Okay, confusion? Yeah. Let's use an example. Let's say that you've got a township where the local girls softball team has won the state championship. Okay, quite an accomplishment. And the township has decided this is worthy of recognition. So they appoint an ad hoc committee to oversee a kind of a recognition ceremony. Maybe there's going to be a parade. Maybe there's going to be, like a community cookout or something like that. And we're going to celebrate this really important accomplishment. Well, I think most people could argue that this is not an essential government function. Okay, is it important? Yes. Is it worthy of recognition? Yes. However, government would still run if you didn't have a parade and celebration for the accomplishments of the girls' softball team. So I think we would argue this is not an essential government function. Okay, but let's turn this around a little bit. Let's say that the council appoints a committee to review all existing ordinances to make sure that they are still legal, that there's no conflicting case law, that the language is up to date, that we don't have redundant or conflicting laws and ordinances in any way. All right, that I think you could argue is an essential government function, to make sure that all of our laws are relevant and up to date. Okay, so you can see the distinction there. First one, girls softball team, probably not subject to the Sunshine Act. Second one, probably is. Okay, then we further expand this definition that exercises authority to take official action. Okay, and then we look at the definition of official action in the Sunshine Act. And wouldn't you know, it includes the term making recommendations. Okay, so making a recommendation back to the main council or main board or, city council would be, or school board for that matter, would be considered official action and thus would be covered by the Sunshine Act. Now you're thinking, okay, well, what committee wouldn't make recommendations back to the main board? Well, it could be that the committee is tasked simply with fact finding. You asked us to research this particular issue. Here are the findings of our research, and you would provide that to the main board without any sort of recommendation. Okay, that fact finding exercise, thus any meetings of that committee would not be subject to the Sunshine Act. And also, quite honestly, there are some committees that are appointed simply to make an issue go away. That sounds rather jaded for me to say that, but I've been around a while. I've seen how some boards act, and yeah, when you have certain issues that don't require immediate action, and maybe the board is not quite settled on what, if any, action should take place, how do you get rid of it? Well, you appoint a committee, and that committee usually is never heard from again. That's just the realities of how our democracy works. Sometimes it's not pretty, but if it's not making a recommendation back to the board and not tasked with making any sort of recommendation, then it's not subject to the Sunshine Act, and thus that would not be required the committee would not be required to have open meetings. Okay, but let's dive into this issue a little deeper. And many years ago, decades ago actually, there is a decision called Ristow versus Casey. Okay, it comes out of the Pennsylvania Commonwealth Court, where they provided some very useful language in its analysis and its discussion that further dives into whether or not a committee is covered by the Sunshine Act. And these are some considerations that the court put forth and questions that need to be answered. First, does the committee have any decision-making authority? Kind of goes back to a little bit on the actual definitions found in the Sunshine Act itself. Is this committee tasked with making any sort of decision on behalf of the board, on behalf of the government entity? If not, maybe it's not subject to the Sunshine Act. And like I said, there are some committees that are appointed purely for fact-finding. Then, are the committees appointed by the board, and are they authorized to take action on its behalf? Now you're thinking, well, what committee wouldn't be appointed by the board? Interestingly, there are some committees that are self-appointed or self-sustaining. Good example, and one that we seem to have a lot of questions about this spring, are public libraries. The governance of public libraries across the Commonwealth varies greatly, where there are some that the nexus between the local municipality and the library board is very strong. Okay, all of the members are appointed by the local government. They report back to local government for any decisions or budgetary issues, et cetera, et cetera. But then there are also those library boards that, the nexus is very weak. And for instance, if there's a vacancy on the board, it's not appointed by the local government, but rather the remaining members of the board are tasked with going out and finding a replacement. In that instance, you could argue very readily that the members are not appointed by the main board, but rather it goes back to the library board. Then are they authorized to act on behalf of the board? That's something that's worth looking into, because if they are, then you're meeting this definition under the court language. Then we come up to the next one, which I think is very important. And understand, these all build upon the prior considerations here. But this one, like I said, I think is critical. Are the recommendations pursuant to statute, ordinance, or regulatory authority whereby the making or enacting. Okay, let's break this definition down and think about it. Because if we go back to the example that I used earlier of the girls softball team, you're not going to find a statute that says if your girls softball team wins the state championship, you must have a parade or some sort of recognition ceremony. Okay, there's no statute to support the mission or role of this committee. However, if I go back and use the example of reviewing all ordinances, I think you will find that in statute. And it does become germane. It does become critical to what this definition is all about. Okay, and results in the enactment of laws, policies, or regulations. Okay, now policies kind of opens this up. What's a policy versus a regulation? I kind of view it as non-statutory versus statutory. But the fact that policy is in there greatly broadens this component of the definition. So what's a policy versus, like what's a practice, what's a procedure, et cetera, et cetera. That can be a very subjective component of the definition. So I would exercise caution there during this thought process. Okay, so you still may not be clear on whether is our committee subject to the Sunshine Act. Should we open this up to public scrutiny? Obviously, we're the Office of Open Records. We're the state office responsible for government transparency. So we're going to say, lean towards transparency. Open your meeting up to public participation and observation. And there's a practical perspective as to why I say that. If let's say that your meeting should have been opened up, but you didn't. You decided it's too inconvenient to do that. And we'd rather not have the public available so that, we can get through this quickly. Let's say that someone challenges that. Let's say they file a complaint. The result is you could find yourself standing up in front of a judge trying to explain why you didn't open up your meeting to public scrutiny. And if the judge disagrees, the potential is you could be subject to sanctions. And we'll talk about those sanctions toward the end of the presentation. I think, despite the inconvenience, it makes a lot more sense that when in doubt, open up your meetings to the public to avoid that potential embarrassment and the very real threat of sanctions against not only your agency, but the members of the board directly. Let me get a quick sip of water here. Next question that we have to answer is that, is it a meeting? Okay, and again, we go to the definition section and take a look at how they define a meeting. And there are some questions that we need to consider. First is there going to be a quorum? Because if there isn't a quorum, then you cannot conduct any official business, and it wouldn't rise to the level of a meeting at that point, because it actually becomes kind of pointless to have a meeting if you don't have a quorum. Now, some specifics about how a quorum can operate. Can members phone in and participate? Yes, they can in most instances. However, case law dictates that the person phoning in order to reach a quorum, needs to be able to hear everyone else in the meeting, and everyone else in the meeting needs to be able to hear the person phoning in. Okay, so it's kind of like a conference call arrangement, or if you're using an online platform, like Skype or Teams or whatever platform you're using. Sorry about that. What we're saying is that there can't be an intermediary. There can't be a middle person who would like be sitting at the dais with a cell phone up to their ear. Well, Fred says this and Fred votes this way without everyone else being able to hear Fred. Okay, so no intermediaries. It has to be direct communication for someone to be able to, for a board member to be able to phone in to participate in the meeting. Now, under the Pennsylvania Borough Code and also the First Class Township Code, the quorum must be physically present. Okay, and then anyone above and beyond a quorum can phone in to participate. There's no problem with that. Okay, but for like second-class townships, school districts and the like, yes, they can phone in order to meet the quorum requirement. Okay, then the next question we have to answer, is there deliberation? Sunshine Act defines deliberation, and I'm paraphrasing here, is that any discussion that ultimately leads to a decision. Now, that doesn't require that a decision be made, because maybe the decision is we're not going to take any action. And when we use the term decision, that's a vote for all practical purposes, okay? So deliberation, discussion that leads to a vote, or perhaps the decision not to vote. And then decision-making is the vote itself. And then we just want to caution you to beware of email meetings. And this is actually more common than you would think. Usually it happens, at the beginning of the year where you've got a new board appointed, and maybe they make up a majority. Typically, many members might be from a business background, where in that environment, using emails to get work done, it's fast, it's convenient, it makes sense from their perspective. However, under the Sunshine Act, that would be considered a violation, because all deliberation, all decision-making needs to take place in a public setting. So beware of those email conversations that could be construed as not only deliberation, where you're discussing matters of business import, but also any decisions that might be made using emails, okay? Because you could find yourself getting in hot water there. There is a distinction that I want to make, though, and that is for administrative level decision making as opposed to policy level decision making. I'll just use a quick example here. The policy decision making would be in the form of a vote. And let's say at the last regular public meeting, a vote was passed that we're going to approve, our township has enough money to pave 20 miles of roadway. Okay, so that, and we're approving the township staff to go ahead and do that. Okay, so that's the policy. We're voting to approve paving 20 miles of roadway. But then between or after that meeting, the question comes up, which roads or what part of which roads? Certain intersections, let's figure out what roads are going to be paved. Okay, well, the vote to pave the roads has already taken place. Now we're just going to decide how to implement or fine-tune that previous vote. That discussion is administrative in nature because the policy level vote has already taken place. So we can have email discussions, deliberation, and that administrative level decision making take place using email outside of the public eye. Okay, again, somewhat subjective, and it's going to depend on the specifics of what that discussion is, but hopefully I've explained the distinction between policy level and administrative level. With administrative level, for the most part, the rule of thumb is that the big decision has already been made, and that's been made through an appropriate public vote. Okay, now the small stuff, figuring out how to implement that vote, that's administrative in nature. Okay, what is not a meeting? And this comes up. Well, yeah, I've already explained the one, administrative action versus agency business. So we've got that covered. But it used to be, or still is, that we would get phone calls. Hey, I saw our 3 township supervisors at breakfast the other morning at the restaurant. That's illegal, isn't it? Well, no, it's not. Okay, they can get together and they can talk about the weather, their families, et cetera, as long as they're not discussing township business. Okay, then it's not deliberation. All right, and the question has come up periodically. This one actually comes up fairly frequently. Our school board wants to attend, a celebration for the girls softball team that won the state championship. Okay, but we can't have a quorum attend all at the same time, right? Well, no, that's not the case. You can have the entire board show up for the celebration or the recognition ceremony as long as they're not talking about school district business. Okay, that's fine. Okay, so you will occasionally have work sessions. And I think the Sunshine Act only mentions work sessions as it relates to township auditors. But this applies to any board where I think school districts are probably the best example, where they have a monthly business meeting that's open to the public, where they have deliberation and discussion, but they will also have a monthly work session that isn't open to the public. And an appropriate work session, the communication is basically what I would define as one way, meaning that the board is sitting there hearing reports from the superintendent, from other staff on issues of import that they may be expected to vote on at the next public meeting. And it's for educational purposes. Okay, the board members hear from the superintendent. Individual board members may have questions for clarification or further explanation. However, the board members cannot discuss the merits of the topic amongst themselves, because as soon as they do that, it's deliberation. You can have discussion back and forth between board members and staff, but the board members cannot discuss the issue amongst themselves, because that would be deliberation, and deliberation must take place in a public setting. A tip-off is that where you would have a public meeting, the board comes in, an issue comes up on the agenda, okay, and then, all in favor without any deliberation. That's kind of telling you that probably they discussed this matter outside of the public eye, and yeah, it raises some red flags. So during these work sessions, conferences, retreats, or whatever, number one, no deliberation, and number two, no decision making. Okay, no votes, no polling the board members to see, what they think or how they would decide on something. Okay, because that would be, a de facto decision. Okay, page down here. There we go. All right, let's talk about this first leg of the stool, public notice. In order for a board to adhere to the Sunshine Act, they need to provide advanced public notice of any public meeting that they're going to hold. And the way that this usually works is that before the first organization meeting, the first meeting of the year, whether it be, whatever their calendar is, the fiscal year, calendar year, however they work it, 72 hours in advance of that first regular meeting, the notice needs to be published in a paid newspaper of general circulation. Typically, it's one of those legal notices, the fine print, thin columns, but that's what, the common practice is. It can't be a newspaper article or what's commonly called a puff piece, where they interview, maybe new members of the board and then decide to mention, just as an off paragraph. And by the way, the board meets the first Tuesday of every month. Okay. Now it's got to be that legal notice. Having a notice on a website, while that's a good practice, and we'd recommend you continue with that, that does not satisfy the language in the Sunshine Act. And those free sales circulars that show up in your mailbox 2 or 3 times a week, they don't count either, even though they may cover local news like the girls' softball team. It has to be a paid newspaper of general circulation that serves the jurisdiction that the board is responsible for. Now, I'll just go off script a little bit and say, yeah, we realize this is a growing problem because of structural changes that are occurring in the news media industry. And it's becoming harder and harder to find paid newspapers of general circulation. But until such time that the legislature modifies the Sunshine Act, this is what you have to deal with. So you want to make sure that your advance notice is, you've got the process started far enough in advance that it gets to the newspaper in time for publishing at least 72 hours before that first meeting. And then usually what occurs is that in that same notice, you would put the dates for the expected regular meetings throughout that calendar or fiscal year. So if it's the first Tuesday, you sit down with your calendar and figure out the dates. Now, let's just say that, once they have the organization meeting, it comes up that this is in conflict with a couple of our work schedules, and we just can't meet the first Tuesdays. Can we change it to the second Tuesday? And they take a vote and decide that's what they're going to do. Okay, perfectly acceptable, but then you have to run a second public notice at least 3 days in advance of the next coming regular meeting to make sure that the public is notified that we're changing our meetings from the first Tuesday to the second Tuesday, or however you work it. Okay, so that's how that would transpire. And then that same notice also needs to be posted at the meeting site, the conference room, the meeting room, wherever, where the meetings are typically held. Now, let's say that an issue comes up that cannot wait until the next month's meeting, the regular meeting. The Sunshine Act has a provision that allows you to have special meetings. And these would be a regular business meeting where there's going to be deliberating and decision making, but not waiting for the next monthly meeting. Okay, so you advertise again using the same standard, a paid newspaper of general circulation. It's just that now, rather than 72 hours in advance, it drops down to 24 hours in advance for a special meeting. And, this could be something regarding bidding a project where you've got to get notifications on the successful bids out within a certain time frame. It could be any number of issues that come up where a special meeting is required. 24 hours advance notice, and you're good. Then you have emergency meetings where there is no notification required. And typical example for an emergency meeting that I like to use is snowplow purchase. Okay, let's say that we're talking about a small borough or small township that only has one snowplow, or a limited number of snowplows. And one of them breaks down, and it's so old that we can't get parts for it anymore. No one will work on it because of the old technology, whatever. And the forecast says that there is a big storm coming, and it's going to dump on us tomorrow night. So we got to do something quick. And it so happens that the roadmaster came back and said, look, down in the next town, there's a dealer with a snowplow sitting on the lot. You know, we can pick it up for this price, but we need to move now because of the forecast. Okay, call an emergency meeting, council meets, they hear out the roadmaster or, you know, director of public works or whatever, and they vote to purchase the new snowplow. Okay, perfectly legitimate. And I think, you know, it would pass what I call the straight face test, meaning, you know, if someone complains, could you stand up in front of a judge and explain your reasoning for this emergency meeting with a straight face? Meaning, obviously in this case, you probably could. However, I want to caution you about creating your own emergencies to justify having an emergency meeting just so you can take action outside of the public eye. Okay? Chances are, if you try to outthink the Sunshine Act, you're going to get caught. Someone eventually will bring it to the public light and someone will file a complaint, and you'll find yourselves having to explain this to a judge. All right. We've got a history here where almost in every instance where this has occurred, you know, judges have not taken this lightly and there have been sanctions. But usually the situation is where, you know, someone just thinks, well, you know, this is too controversial. I don't want to sit through another meeting that's going to last into the wee hours of the morning where people are yelling at each other, where people are yelling at us. Let's just come up with a way to justify an emergency action here and get this behind us. You're going to get caught and you're going to get called out on it. So please do not try to outthink the Sunshine Act. Okay, you're going to save yourselves a lot of headache and possibly a lot of money in the long run by doing it the right way. Now, if you have to cancel a regular meeting or a special meeting or whatever, let's say that, you know, someone's sick, you can't get a quorum together, or, you know, just what forever reason, you can't hold your regular monthly meeting and you have to cancel. Under the Sunshine Act, there's no requirement for notification of a cancellation. However, I do recommend continue to use social media, your websites, your Facebook pages, your Twitter accounts, whatever, to let the public know that you're canceling the meeting. All right, no legal requirement to do that. However, what about those people that normally show up and, you know, they show up that night and the building's dark, the doors are locked, and there's nothing, you know, the next day they find out, oh, well, we canceled the meeting because we couldn't have a quorum. You know, do whatever you can. It's just good public service to let people know that you're canceling the meeting. You know, like I said, just for good public service and keeping everybody happy, because I would rather that the public be happy than that one unhappy person that spreads the word, you know, guess what they did, okay? All right, agendas. Another sip of water for me here. This is, I want to say, relatively new. It's almost a year old, new provision of the Sunshine Act, but it is a requirement that now all agencies must post an agenda of issues to be deliberated on or planned official action at least 24 hours prior to the public meeting. And this was in response to complaints from people who said, you know, our board doesn't tell us anything about what they plan to do that night. And occasionally they'll try and sneak something in, you know, that's really important, that involves spending a lot of tax dollars on meetings where there's not a lot of public in attendance. And, you know, this just isn't right. So the legislature passed this provision, this addendum to the Sunshine Act, to address this. So at least 24 hours in advance of a public meeting, the board needs to post an agenda of all items that they expect to either deliberate on or to take a vote on. Now, the question has come up, how detailed do these agendas need to be? And my response to that is apply a common sense standard. Okay, look at it from the public's perspective, who may not be familiar with all the intimate details as to what the board is talking about, and provide a sufficient explanation so that a reasonable person understands the issue that the board is going to be acting on that night. Okay, that hopefully that makes sense. All right, and then this standard or this requirement for agendas applies to regular meetings and special meetings that you might hold with that 24 hours advance notification notice. It doesn't include work sessions, conferences, or executive sessions because they're not, by definition, open to the public. Okay, so there's no agenda requirement for those. Now, the agendas are required to be posted on websites if you have one. And we've noticed a trend with local municipalities and school boards where they may not have a website, but they use like a Facebook page as their main social media outlet. So if that's the case, then the requirement would apply to the Facebook page. How does the public find out about what you're doing? How do you get information out to the public? If it's through a Facebook page, then your agenda gets posted to the Facebook page. Let's say you have both. Well, ideally you would use both, but then the legal requirement is only for the website. Okay, then the agenda also needs to be posted at the meeting site, and copies of the agenda need to be available to the public as they are coming into the meeting. Okay, what if the board wants to change the agenda? Well, there's a timeline that needs to be followed here. And let me try and walk you through this. Now, anytime before the 24-hour threshold hits, you can change anything on the agenda you want to, okay, pre-24 hours. Okay, but once the 24-hour threshold hits, in that window between 24 hours in advance of the meeting and when the meeting is called to order, only de minimis changes can be made to the agenda. De minimis would be defined as there's no expenditure of funds as a result of the vote, and you're not entering into any contracts, okay? If you are expending funds, if you are entering into a contract, those would not be considered de minimis, and you could not make those changes to the agenda. Now, let's say that the meeting is then called to order. Changes can be made. If it's brought up by the public, the board can defer it for consideration at a future meeting. It's really up to the board as to what they want to do. They can decide we will act on it, or we're just going to put this off for consideration at a future meeting. If the board does decide that they're going to act on a new issue, whether it be brought up by the public or by a board member, they can change the agenda, but the change must occur by majority vote. So for practical purposes, two votes take place. The first one would be the vote to change the agenda. And it would be handled, just like you do with Robert's Rules of Order or whatever rules you used for the conduct of your meeting. First vote, I vote we change the agenda. And then you have the deliberation, public comment, or whatever order you do, as long as public comment's allowed before the vote. And then you vote to change the agenda. When you do that, the chairperson or president must explain to the public why you're changing the agenda. Okay, and then the second vote, which may or may not occur, would be the result of discussion of the new agenda item. And I say the vote may or may not occur because the decision may be, well, we're not going to do anything. Okay, so, but you would have those two distinct processes occur. First one, change the agenda. second one on the issue itself. And all this would be reflected in the official minutes of the meeting because it does involve deliberation and a vote to change the agenda. And if you do change the agenda, then the amended agenda reflecting that change must be posted within 24 hours after the public meeting. The question comes up, well, how long then does it need to be posted? The Sunshine Act doesn't say. However, follow my logic here. Since you've got this 24-hour window that the agenda needs to be posted before the public meeting, it kind of makes sense that you would post the amended agenda for 24 hours once it's posted after the meeting. Now, I'll caution you. Hey, someone was reading my mind here when they posted. Okay, 24 hours, Pam, is my answer. Now, that is not written in the law. Okay, that is simply George's uninformed wag guess as to what makes sense. Ultimately, someday, a judge may take exception to that. All right, but I think in the meantime, you can tell the judge, well, this is what George thinks, and we'll see how far that gets you. All right, but that's what I would do if I were sitting on a board and had this issue, if I were a board secretary and you know, had to deal with this. Okay, and then remember, like I said earlier, the minutes must reflect all of these changes because the minutes are an official record of all deliberation and all action that took place at the public meeting. All righty. Okay, public comment, third leg of the stool. Commenters can be limited to residents and taxpayers of the jurisdiction that the board sees. Occasionally, you have someone come in from out of town who wants to comment. Maybe it's an adjoining township or borough or school district or whatever, and they feel they have something to say. The board is within its rights to say no, because you're not a resident or taxpayer. Sometimes, and I think, you know, ultimately this may result in some case law one of these days, a group of citizens will ask a professional from an outside organization to come in and comment before the board on their behalf. As it stands now, the board can say no. But I think as we're seeing more and more of this occur, I think it's going to end up in front of a court one of these days. I just sense that. Okay, I see a trend coming up, and this being an issue one of these days. Another thing that I saw recently, actually it was several months ago, where it was a public meeting during public comment where there was a guy with an axe to grind. So he got other members of the public in attendance they signed up for public comment. And then when it came time for their turn, they say, I defer my time to this guy. Okay, now, if you're dealing with Congress or the state legislature, yeah, maybe you can do that. But for purposes of the Sunshine Act and public comment, I'm not so sure. I'm not very comfortable with that practice, because what basically happened is that this one guy got to speak all night, okay, because everyone else was saying, I give this guy my time, okay? I'm not sure the board had to do that, all right? And maybe, you know, upon review, the solicitor for that board would agree, but I'm not sure how it turned out. I hadn't heard of it being repeated, but yeah, once that was explained to me, I was a little uncomfortable with that occurring, because it allowed this guy to monopolize the public comment period. And I'm not sure that's something, you know, as a board member, I would have been comfortable with. Now, when you look at the public comment language, it says that the public has a right to comment on issues that are or may be before the board before any pertinent votes. What's problematic with this phrase is may be. before the board. Okay, that basically is saying I can comment on anything I really want to comment on, because ultimately this issue might come before the board. Maybe it won't, but maybe it will. So this kind of accommodates that guy who the item's not on the agenda, but he wants to complain about the potholes on his street. Okay, so he's allowed to do that per this component of the definition of public comment that's included in the Act. Now, I'll talk about this in the next bullet point here, and how a board can potentially deal with this issue. Because the board can establish reasonable rules for public comment. Usually, that's in the form of time limits, okay? Everyone's going to get 3 minutes, and maybe they actually vote on it as part of their meeting procedures, where we're going to decide that for public comment, everyone gets 3 minutes. Well, a board can also change that. They can set the rules aside for a particular meeting. You know, let's say there's an important issue. Or, you know, maybe there are not many people here tonight, so we'll give them a little bit of extra time. Or maybe because of everyone who's here tonight, we're going to have to reduce it down to 2 minutes, just so everyone has a chance to get, you know, their public comments in, and we're not here till the wee hours of the morning. Okay, as long as it's reasonable, and those rules are not intended to thwart the public's right to comment on issues that are before the board. Where you want to be careful is in how you limit what the public can comment on. There is some case law out there, some practices from last year. I'll just name names. The Pennsbury School District had an issue where some meetings were being attended, and they got quite adversarial, and, you know, the public was exercising its right to comment. The school district adopted a policy put out by, I believe this is how it worked, it was put out by the School Boards Association, that limited public comment to only issues that were before the board and very specific in how the board interpreted these issues. And there's some actual YouTube videos out there where if the commenter did not use specific language in describing the issue that they were commenting on, the board said that the comments were not relevant, and they shut the comments down. They told the person, you know, well, basically they used the term, you're done. Okay, and I'll just leave it at that. Okay, but this resulted in actually some federal lawsuits where at this point the courts were agreeing with the commenters that their First Amendment rights were being shut down. So the point that I'm trying to make is be very cautious, you know, if you're on the board side of this, as to how you deal with these reasonable rules, because the initial court decision basically said this policy was not reasonable. It's too vague and allowed the board too much discretion in determining what was relevant and what was not relevant. Okay, another reasonable rule that we've seen is the board asking members of the public to appoint a spokesperson. Let me just throw out this example. Let's say that there's a particular issue coming up for vote tonight that's attracted a lot of public attention. You've got a group come in and they're all wearing the same t-shirts and they've all signed up for public comment. Okay, perfectly acceptable for the chairperson to go over to that group and say, look, in order to save us time and to make sure that everybody has a fair say tonight, would you agree to appointing a spokesperson to make sure that all of your points are covered, that, you know, there's no redundancy? We'll even give this spokesperson some extra time. Okay, so rather than the typical 3 minutes, we'll give them 10 minutes. Okay, would you agree to that? And, you know, that is perfectly acceptable. And oftentimes the group would be agreeable to that. Okay, then there's another point where this addresses that maybe language before the board. And this is where you have a specific comment period and a general comment period. The specific comment period would be for matters that the board is getting ready to vote on, and we've had our deliberation, we're getting ready to vote, so now we'll allow public comment on this specific issue. And the board would go through and allow that. Then at the end of the night, you would have a general comment period where the guy complaining about the potholes on his street could then stand up and make his general comments. All right. There's absolutely nothing in the Sunshine Act that speaks to this. Okay. And there's no case law that speaks to this. However, I am aware of a number of municipalities that have adopted this practice, and they've let me know that it works for them. Okay. I'm not saying you must do this. I'm simply putting it out there as a best practice. Maybe you want to take a look at it and see whether or not it would work for you. If not, no harm, no foul. But the idea is out there for you to consider. Okay, so much for public comment. Let's move on and talk about executive sessions. Okay, Haverford School District does that. Great, good to know. And I'm glad it works for you. Okay, executive sessions are gatherings of the board that occur outside of the public eye because of the sensitive nature of the issues that they need to discuss. Okay, let me backtrack. No other questions come up. If you have a group agree to a spokesperson speak for all, do you have to note the agreement in the minutes? I don't think you have to, but it certainly wouldn't hurt to have some sort of documentation that that's what you did in case the issue comes up again, or if it's challenged in any way. The fact that you've documented that your chairman approached this group and they were agreeable to it, I think is I think you are limiting any potential liability. Plus, you're not hurting anything by documenting what you've done. Okay, yeah, that's a good question, and I think I would recommend doing that. Although, again, there's no legal requirement that you do that. Okay, executive sessions, sensitive issues. All right, so an executive session can be held by the board before, during, or after an open meeting, or they can announce during an open meeting that we're having an executive session at some future point in time. And then they would have to give the date and time as to when they're having it. When they give the notice for the executive session, they have to give the complete reason as to why they're doing it. For instance, it is a common practice for the chairman to simply stand up and say, we're going into executive session for personnel reasons. Okay, well, it turns out there is case law that says that's not good enough. You have to give the complete reason why you're going into executive session. And the case law is Reading, City of Reading versus the Reading Eagle, Reading Eagle being the local newspaper down in Berks County. And the practice was just what I described. We're going into executive session for personnel reasons. Reading Eagle took issue, they filed suit, and the Pennsylvania Commonwealth Court issued a ruling that agreed with the Reading Eagle. And essentially, I'll paraphrase the decision, but it goes back to that reasonable person language. And the court said, look, when you're going into executive session, you are essentially taking it on the public's trust that you're meeting in secret. So you have to return that trust by providing enough of a reason that a reasonable person can discern that you're going into executive session for an appropriate reason. And simply saying personnel or legal matters is not good enough. So for personnel, you might have to say, we're going into executive session to discuss, for instance, potential disciplinary action against one of our employees for an infringement of the work rules. Or if you're going into executive session for legal reasons, if someone has filed suit against the city or the township or the borough or the school district, you would give the case citation. XYZ Corporation versus our school district. Okay, so that, at the very least, the person can go down to the court and look up the filings on it. All right. And you would let them know that there, in fact, is a legal action that the board needs to meet to discuss. Okay, so the complete reason. Now, for an executive session, there's no requirement for minutes. And if you do keep minutes under the right to know law, those minutes are exempt from public disclosure. No official action can take place during an executive session. Any decisions, meaning a vote, must occur in a public session. So let's go back to this example about disciplinary action. During executive session, you hear from the HR office, maybe the employee's representative has the opportunity to make their case, and then the board deliberates amongst themselves, and maybe there's even an informal polling. Well, what do you guys think? Is this worthy of a suspension? Okay. That vote, however, the official vote, cannot take place in the executive session. Rather, they would adjourn the executive session, come back and reconvene the public session. And at that point, they would take the official vote. Okay, all in favor. And at that point, they would do the official action to suspend this employee for 5 business days or, whatever the decision is. That must occur as part of the official record of the public meeting. Okay, they cannot decide something in executive session and not do something in public session and expect it to be considered an official action of that particular board. Reasons for executive session. Okay, like I said, personnel matters, hiring, firing, discipline. I want to stipulate, though, that this involves individual positions and individual employees. If you want to talk about, for instance, your leave policy or your discipline policy, that is a policy matter, not a personnel matter. And that discussion must occur in public. Yeah, enough said. Discussing labor negotiations, yeah, you would not do that. You would not reveal your bargaining strategy in a public meeting where teachers or your unionized employees might be sitting there participating. Considering the purchasing, leasing, or selling of property, the law does not include the term selling. However, there is an unpublished Commonwealth Court decision where the court says, look, if you can do purchasing in an executive session, you can do selling in an executive session. Consulting with counsel about litigation, avoiding violating privilege. This is where your solicitor wants to have a discussion with the board, and any sensitive matter discussed can occur in a confidential setting where the solicitor is providing legal guidance and advice. Discussing university admission standards. I don't know, maybe in the 1950s, this was important at the time they wrote the law. And then a newer one, discussing emergency preparedness, stuff like homeland security, maybe evacuation plans, active shooter plans, that kind of stuff. Okay, that can occur in executive session, obviously for issues of emergency preparedness. All righty, violations. What if someone thinks your board, oh, do all executive sessions have to be held during the public meeting? No, Pam, like I said, the board can announce that an executive session is going to be held at a subsequent date and time. Okay, usually that occurs just due to scheduling conflicts and the like, or, this meeting has lasted long enough. We need to have an executive session to discuss one of the issues, but we can't do it tonight because everyone's fallen asleep. So maybe we'll have it tomorrow night or, someday next week, whatever, as long as it's announced to the public, the date and time of the meeting. All right, violations. Well, first offhand, let's say that someone thinks during an actual meeting that the board is violating the Sunshine Act. The act allows that person to address the board and say, look, I think your action here is in violation of the act. And then they sit down and, they basically have given notice, okay? They're allowed to do that without being considered out of order. All right, but enough said. Now, if the board agrees, and it's like, oh yeah, you're right, we forgot to do this, or we did that improperly, the board can cure the violation right then and there. We will take a vote. in public, and we'll do it right now. Okay. Or yeah, you're right. We forgot to allow public comment. Okay, we're going to go back, allow public comment, and then revote. Okay. They are curing their violation. However, if the board doesn't agree with the person raising the issue and they go about regular business, that person, if they're so inclined, has 30 days where they can file a complaint in the appropriate court. Now, if it's a local government agency, city, borough, township, school district, they would go to their county court of common pleas and seek legal relief. And it could be, I want an injunction on any further action. I want you to void this particular vote. I want you to void the meeting, okay, because of the nature of the violation, whatever, okay. If it's a state agency, then it goes directly to the Pennsylvania Commonwealth Court, and, the same process. All right. If there is any suspicion of criminal intent, the person could also go to the county district attorney. The district attorney would violate the alleged criminal activity. The court, however, would investigate the Sunshine Act violation, the civil issue. And both could go on at the same time, but understand that the district attorney, in most cases, would not rule on whether or not it's a violation of the Sunshine Act. They would only rule on whether there was criminal intent or not. Okay. And then the judge has a fair degree of discretion. Well, first offhand, they usually end up holding a hearing. And that's where that straight face test comes into play. But, they would hear the parties out and then rule. And let's say they rule against the municipality. They have a fair degree of discretion in what they can do. Like I said, they can void a vote, they can void an entire meeting. Maybe, if they consider the violation particularly egregious, they can levy fines. And those fines are paid by the officials in violation, not the agency. Okay, so if you've got, let's say a school board violated the Sunshine Act, the judge could fine the board members, and the district can't write the check. The board members have to pay out of their own pocket. And it could be up to $1,000 for the first violation, $2,000 for the second. All right. We've also had some judges come up with some creative resolutions where they have ordered that board members attend training. And for instance, I did one last year with the, I think it's the city of Menneson. Yeah, where the judge ordered training for the mayor and a couple board council members, and I did that training for them. Okay, so, and we've seen a couple similar rulings since then. So yeah, judges do have a lot of leeway in how they can resolve Sunshine Act violations. And by the way, the fines, the payments go to the courts, not to the complainant's pockets and not to the Office of Open Records. Okay, then just some miscellaneous provisions here before we wrap up. The Sunshine Act says that the board must produce meeting minutes recording board attendance, who voted for and against. Okay, so if it's a general vote, it's yay or nay. Did the motion pass? Was the motion defeated? If there is a roll call vote, then how each board member voted must be recorded in the minutes. Notice that there is nothing in the minutes requirement about public comment, okay? But I'll leave that to you to figure that one out yourself. The public, okay, another provision, the public can record public meetings unannounced, and it's not a violation of the Sunshine Act or the Pennsylvania Wiretap Act. I can, for instance, set my cell phone on record, put it in my pocket, walk into a public meeting, and I'm not in violation of any law. There is no expectation of privacy at a public meeting. And then if the agency is recording the meeting, those recordings and the minutes generated for that public meeting are considered public records and are accessible under Pennsylvania's right to know law. Okay? All right, well, we are now at the end of the presentation. Thank you for your participation today, and thank you for the good questions. If you do have any further questions, now's the time to get them in, okay? And one has come in, recent amendment to the Sunshine Act. I am assuming the 24-hour agenda notice. Was that policy prior? No, that became effective. The agenda notice became effective August 29th, 2021. Okay, it did not, there was no agenda requirement prior to that. Do recordings qualify as minutes? No, they do not, okay? Recordings are a verbatim, transcript of what occurred, but they do not constitute minutes as far as the Sunshine Act is concerned, or the appropriate statutory code, like the Borough Code or the First Class Township Code. Okay, they have their own requirements. Okay, lots of questions coming in here. Make sure I don't miss any. Okay, can they send the public out of the room during a public meeting? If the only way they can have an executive session, meaning that discussion outside of the public eye, is to have the public excuse themselves and wait outside of the meeting room, yes, they can do that. Okay, that is, that's a common practice. If one files in the Court of Common Pleas, are the court costs returned to the filer? That depends on how you file. You would have to raise that issue in your filings, that there's nothing automatic in the Sunshine Act, I guess is what I'm saying. Rather, as part of your filing, you would say, oh, and by the way, I want all attorney fees and filing fees paid by the district if the judge finds them in violation. Again, that's up to the judge's discretion. And it's really a separate legal test as to whether the person filing the complaint is entitled to costs that the judge would go through in determining whether or not that in fact occurs. Is there a new amendment being considered? Maryland, there are always amendments being considered. It just depends on what kind of traction, if any, they gain in the legislature. Sometimes they die in committee, sometimes they come out of committee and they'll never be considered by the floor. Sometimes one house will pass, but the other house never takes it up. It just depends. At this point, I think it's safe to say that we're not aware of anything on the horizon, the immediate horizon, that we see the legislature passing at this point. But, kind of like with the agenda, we had about a week's notice when that one finally gained traction and it looked like the legislature was going to pass. Okay, what is a reasonable amount of time for individual public comment? Drew, I think that's going to depend on the particular situation. Usually what we see are like 3 minutes, 5 minutes, or the like. And like I said, the board has the option of changing that. They can vote to set aside the rules for a particular evening if there is, an unusual set of circumstances. But usually 3 to 5 minutes is what we see. Again, no legal standard for that. Carolyn, what about sending the public to another room because one of the board members yelled at the public and said, if you don't like answers you're getting? Well, Carolyn, that's kind of outside of the Sunshine Act, and I think you've got bigger problems to deal with there. I'm not aware of anything illegal. As if you're forcing the public or compelling the public to go to another room, what you've got to look at are the standards of the Sunshine Act still being satisfied? If you're sending them to like a timeout room and they can no longer observe the deliberation and the decision making, they're no longer able to make public comment, then you have the potential for a violation. But if that other room, you can still hear and witness what's going on, I think then, it's more of a gray area that you'd have to take a look at. But like I said, I think you've got bigger problems than the Sunshine Act if that's what's happening. If you post a meeting agenda more than 24 hours, and make a change and upload the updated agenda at least 24 hours before the meeting, must the board announce the agenda was changed? No. If the change occurs more than 24 hours in advance of the meeting, you're good to go and you can make any changes you want to. It's that 24-hour window immediately prior to calling the meeting to order that you need to be careful about any changes and how they occur. Okay, are Zoom recordings of the meeting required to be maintained even if minutes are created? No, there's no requirement that Zoom recordings be maintained. Now, I will say this. There is a law, it's called the Pennsylvania Municipal Records Act. It applies to most municipalities, doesn't apply to school districts, where if the municipality has adopted this act, okay, because it's optional, but if they have adopted the Municipal Records Act, the act recommends, and I put quotes around recommends, that if there is a recording of the meeting, then it should be maintained until the next regularly scheduled meeting of that board, and then it can be discarded. Okay, because it's kind of a backup as for how the minutes were created. But again, it's optional for the municipality to adopt the Municipal Records Act. I recommend that you do that. And, there are many municipalities, some deeper pockets than others, that will actually post these recordings on their websites, or at the very least, they'll have them available in case someone files a right to know request. And, the cost is minimal. So, why not go ahead and do that? But, not every municipality has deep resources or the technological know-how to be able to do it. So like I said, there's no legal requirement, but, if you can do it, why not? Okay, Mr. Walker, for boards like zoning hearing boards and redevelopment authorities, can motions be changed based on the discussion during the meeting? All right, zoning hearing boards are kind of like their own animal, and while there are facets that they must adhere to relative to the Sunshine Act, their meetings can also be governed by specific provisions in the zoning, the Pennsylvania zoning, what's it called? Gosh, the name escapes me at the minute, but there is a specific law that governs zoning hearing boards. I think it's called the Pennsylvania Municipal Planning Act or something like that. So you want to make sure that you're actually in adherence to both laws. And if there's a conflict, I would suggest you consult with your solicitor. Changes to motions, I think, a motion is different than an agenda item. So if there's like a motion to amend the vote, or how can I put this? If someone raises an issue, if a board member raises an issue to amend the motion, usually that can occur because it doesn't involve an agenda change. It's specifically agenda changes that you need to be careful of. Okay, and this might be one of those issues where it's so specific that you'd want to take it offline, and I would suggest consulting with your solicitor to make sure you're doing it right in this particular case. Okay, lots of thank yous, and thank you. When official actions are taken place, decisions that will be brought to the board, not just fact-finding, by ad hoc committees, then those meetings of the ad hoc committees, do they need to be public? Yes, if there's decision-making taking place that results in making a recommendation to the board, I would argue that those committees their meetings need to be open to the public based on a couple of things. Number one, you're saying that a vote is taking place. That is a decision. Number two, you're saying that the result of this vote is a recommendation to the main board. That is language specifically included in the act. So I would lean towards opening this committee meeting to the public. Now, let me preface that by saying I am not giving you a legal opinion. Okay, I'm simply using the information you're providing me to give you my impressions as to what that what that committee should be doing. There's always exceptions, and when you delve into it, there's always some sort of fact that could change this. Repeat how to get a copy of this training. Yeah, first offhand, the PowerPoint is available on our website on our training page. The recording that we're making of this session right now, that will be saved and could be available by you sending us a flash drive and a self-addressed stamped envelope with the date and time of the training or subject of the training. It's also possible, I'd have to check with our administrative staff, that they're able to upload this recording to a file sharing platform where they may be able to just email you a link. I think that's where they're at now, but I'm not 100% sure. Okay, but either way, we can get you a copy. Okay, Reading Area Community College, I'm assuming, I'm not sure. For the 30 days for a complaint in violations, is that 30 days from the vote or 30 days from when the complaint realized the violation? Oh, okay, well, you're raising a good point. The answer is yes. If the complainant is aware of the alleged violation, it's 30 days. Okay, so it's usually 30 days from the vote. Like if you were sitting in the meeting and you took exception to what the board did, you got 30 days. Otherwise, it's 30 days from when you discover the alleged violation up to a year from when that violation occurred. Okay, so after a year, you can't file in court no matter what. But up to a year, it's as long as it's within 30 days of when you discovered the alleged violation, then you can file in court. Okay, that's a great point. I usually don't go into it because it's a little too detailed, but great question. And hopefully I've explained that to you so that you understand it. Can a school board meet in an executive session prior to a meeting to preview the agenda for the scheduled board meeting? I would argue no, that if it's considered an executive session, they have to adhere to the reasons within the Sunshine Act for an executive session. Reviewing the agenda is not one of those reasons. Okay, Mr. Robinson. Oh, I see. For organizational purposes. No, I've given you my reasoning there. Okay, a meeting becomes unruly and a public member is unable to hear all the speakers. They wait the required amount of time and request a copy of the minutes which they are given, but feel that is too vague or not verbatim. This is a violation of the right to know rules. I would argue no. CK, okay, I'm going to get into the weeds here, and I'm just doing this because we've got time. Everyone's being very patient, and understand that this is my interpretation of the Sunshine Act. I'm not an attorney. There's no case law to do this, but I am willing to brag a little bit and say my knowledge of the Sunshine Act is probably greater than most attorneys. And here's the point I'm going to make. In the minutes section of the Sunshine Act, there is language used that is different to elsewhere in the Sunshine Act when it comes to what you record in the minutes. All right, now let me explain. The minutes requirement says that you need to have the date, place, and time of the meeting, what public officials were there, who was there, what came up for business, and how did the vote go. And then it says, note of any sworn testimony provided by a citizen. Okay. Most municipalities interpret that as public comment. My view is that that is not public comment, that there is no requirement for the recording of public comment in the meeting minutes. Number one, it uses the term testimony. Testimony is different from public comment. Okay, when you testify, you're sworn in, and that exercise is different. The other term is that it uses the term, I believe it uses the term citizen. Elsewhere in the Sunshine Act, it uses the phrase resident and taxpayer. Okay, that is different from a citizen for legal purposes. All right, now, this whole thing, however, is purely my view. It's not the view of the Office of Open Records, and there is really no case law that justifies my view or that I can point to. It's simply how I would read the law, and if I were a judge and had to make that decision, I would focus on those phrases and how those phrases are different in the public comment section as opposed to what you find elsewhere in the Sunshine Act. Okay, I'm in the weeds here, all right? And I want you to understand I am not providing any legal opinion, and I'm not providing the opinion of the Office of Open Records. But I think if you were to file a violation, these are the legal considerations that you would need, or your attorney would need to keep in mind. Okay. Hopefully I haven't gotten too far into the weeds, and I apologize if I made this too confusing for you. Okay, some other points have come up. Thank you, thank you. All right, we've gone well over, but I'm okay. I can sit here for the rest of the morning and answer your questions. If there are any further questions, now's the time to get them in because I'm getting ready to sign off. These have been great questions, and I appreciate the chance to answer them. And I hope we've given you some clarity as to what the Sunshine Act entails. If you do have further questions, please feel free to reach out to the Office of Open Records, and they'll get you steered in the right direction with any specific considerations that may be necessary. Okay, I think we're good. Folks, I'm going to go ahead and leave the meeting now. But again, in 2 weeks, we'll be having another webinar on payment issues in the right to know law. I hope we'll see you then. Okay, but take care and enjoy your day.